pleasure always to see my friend from Texas, Mr. Roy. And I wanted to just ask a couple of things. One is, he posed the question of whether we're headed in the direction of Great Britain, where he reports a case, which I'm unaware of, about someone being apparently prosecuted or punished for, I don't know, anti-gay speech or something. I don't know what he's referring to there, but I can guarantee you that there's nobody who has been prosecuted for saying that they're opposed to the Obergefell decision or they're opposed to same-sex marriage. That's perfectly covered by the First Amendment. In fact, you could say you're opposed to our whole Constitution, which Donald Trump said yesterday, I think, and that's completely within his First Amendment rights. Of course, you can't incite a violent insurrection against the government as President of the United States, which is moving from speech to action, but he's made himself clear that he's opposed to the Constitution of the United States. But so I don't know whether there are any American cases, Mr. Roy, that you were referring to, but if there is one, I would love to hear about it. I would be far more reassured by our colleagues who keep telling us, like Mr. Burgess, not to worry about the Armageddon of the Supreme Court overturning the Obergefell decision and trying to strip away the right of gay people to get married in America, if they also told us they were opposed to that. But it seems like the people who keep telling us not to worry about Armageddon are the same people who are trying to make Armageddon arrive. So if any of them would say, well, don't worry, Justice Thomas didn't really mean it, or he doesn't have the kind of influence with Alito and the other justices that we think he has, but in any event, I'm with you in standing up for Obergefell, then I could feel a little bit better. But I'm not going to accept assurances from people who are working to overturn the right of gay people to get married in America. But I wanted to ask my friend, Mr. Roy, this question, which I thought was so interesting in the beginning, when he seemed to concede that his amendment violates PAYGO, and therefore what he describes as a technical budgetary threshold issue in trying to become an amendment. And then, but then he says, well, the only way it would violate is if the amendment works. But isn't that always the test? Isn't that always what we ask ourselves when someone offers an amendment? If this amendment works, would it violate the underlying substance of a rule? So why is that in any way unusual?
Well, so my friend from Maryland, I appreciate the question on that one. First of all, I did not concede that. I conceded that the CBO simply said that there would be revenues, fees, and potential expenditures, but that those expenditures would be tied to success. Meaning you created a law and a framework under which American citizens were able to go get damages because the AGs were out of bounds and they won their suit. They won their case. So my point is just not that there isn't potentially a financial impact. I think we're all pretty well aware of my concern about financial impacts when we have bills on the floor. If this were a suspension vote, I'd have concerns about having a cost that's just thrown down on the floor. But I'm saying here, you have the ability as the Rules Committee to make a decision. And, to say that a, $500,000, it could be more, guess by the CBO, and to then kick this out based on the fact that you would have the successful reality of getting the damages is insane. Like, that's the whole point. If we think it's garbage and it wouldn't work, then it wouldn't cost a dime, literally.
All right. Okay, I got you. I got you on that. Let me ask you one final question, which really gets to the heart of the matter, because we seem to have a very different concept of what religious liberty and freedom is. And mine is very influenced by Madison's views as he expressed them in his memorial and remonstrance against religious taxation. And it's about the right of people to worship freely, to pray freely, not to be harassed and persecuted for their religious free exercise. But it's not a right to discriminate in public against other people. In fact, if you go back and you look at the major civil rights cases from the 1960s, the motel owners and the hotel owners and the restaurant owners who wanted to discriminate against Black customers also shrouded their intent in the language of religious freedom, saying, well, it violates our religious principles to serve African American customers, or we don't want to have interracial couples staying at our hotel because that violates our religious precepts. But the Supreme Court determined that when you enter the stream of commerce, you are providing a public accommodation with all of the benefits that you get from society in doing it. You do not have a religious free exercise to discriminate. Your church can discriminate. If your church wants to exclude people of different religions, of course, or different races or ethnicities or interracial or interfaith couples, they can do that. That's what the religion can do. But if you set up hotels and restaurants and office establishments and so on, no, you don't have a right to discriminate against people based on race, religion, ethnicity, and sexual orientation. And I'm just wondering why you think sexual orientation should be different from any other category of discrimination. And I hope you would recognize that people who've wanted to discriminate have always tried to wrap their discrimination in the guise of exercise of their religion. And you're free to comment or not, as you see fit.
Sure, no, happy to. And again, I appreciate the question. I always enjoy the give and take. I wish this were in the House Judiciary Committee and we could do it at length. Two things. Number one, with respect to the question, I'm glad the gentleman acknowledges, which is the very truth that's driving my wanting to offer the amendment, which is the protections offered around which my 12 Republican colleagues in the Senate base their support are highly limited, as the gentleman from Maryland just acknowledges, highly limited to, for example, the word, it's the solemnization, it's the act, it's within the church, it's the act of the marriage, of the action of the pastor or the priest or the bishop. It's not to the more expanded view to answer the question of whether or not, for example, the school that my children go to, or that many other folks' children go to, that might be a religious-based school, can you discriminate? Can you make a choice to not hire somebody that's engaged in a same-sex union at your children's school? I mean, that's a debate. That's a question. It's a question whether is this going to be protected or not protected. And I think that's the debate that I would like to flush out, right? That's part of what we're trying to get at. And then the second thing, to answer your question, I realize that there's often the effort to put this together with the issue of interracial marriage. And I understand. I would associate myself, much to the chagrin, no doubt, of many on the committee, with Justice Thomas's footnote 5 from Obergefell, in which he said, the suggestion of petitioners and their amici that anti-miscegenation laws are akin to laws defining marriages between one man and one woman is both offensive and inaccurate. America's earliest laws against interracial sex and marriage were spawned by slavery. For instance, Maryland's 1664 law prohibited marriages between freeborn English women and Negro slaves was passed as part of the very act that authorized lifelong slavery. Virginia's anti-miscegenation laws likewise were passed in 1691 resolution entitled An Act for Suppressing Outlying Slaves. I will save the rest to say that he goes on to say, the traditional definition of marriage has prevailed in every society that has recognized marriage throughout history. It arose not out of a desire to shore up an invidious institution like slavery, but out of a desire to increase the likelihood that children will be born and raised in stable and enduring family units by both the mothers and the fathers who brought them into the world. Final point being, and it has existed in civilizations containing all manner of views on homosexuality. I yield back to the gentleman from Maryland.
Just to interrupt on that second, of course, if you go back and read Loving versus Virginia, you will see that the dissenters wrap their objection precisely in millennia of moral teaching and moral objections under traditional marriage to making Virginia, compelling Virginia to allow Black people and white people to get married, or to allow white people to marry outside of the white race. So I think that the court in Obergefell made exactly the right analogy. All of this is about some people judging other people's marriages and then trying to use the state to interfere with their ability to marry the person they love. With that, Mr. Chairman, I'll yield back to you.
Thank you.
All right, I yield back.
Thank you very much. Any other questions?